Hi, good afternoon, everyone. Good afternoon. Thank you for joining. We'll be starting shortly. Just waiting for a couple more people to jump on, and then we'll get started. All right. Okay, looks like a couple of us are here. Okay. And can you hear me okay? You should be able to access either the chat or the Q&A box. So at any point in time, if you have any questions or if you have any comments or feedback, feel free to use that tool and I'll be able to see. All right. Seems like a good number of us are here. All right, so we can go ahead and get started. Seems like a good number of us are here. So I'll just get started and then as a few more trickle in, they can just join us. All right. And so as mentioned, as we go through the training, if you have any questions, if you have any comments, feel free to utilize the Q&A box that's available to you. Should be at the bottom of your screen. Okay. All right, so good afternoon, everyone. Thank you for joining me. My name is Xena Robinson, and I am the principal attorney for Mahaniam Law PC, which is an employment law firm here in Massachusetts. And my practice focuses on helping employers navigate workplace risk and employee relations issues like workplace investigations, compliance concerns, high-risk employment decisions, and things of that nature, usually before they become expensive legal problems. Which is why you're all here today. Today's webinar is on can I fire this employee and everything that employers should know before making discipline decisions and termination decisions. So, as mentioned, feel free to utilize the Q&A box as I go through. I will be focusing on questions at the end of the session, just because obviously, just in the interest of time, I want to make sure I get through the material in case there are any questions at all, so that we can make sure that we dive into those before you have to head back to work. All right, so I know this sounds like a simple question, and it's probably one of the most common questions I hear managers ask, HR professionals, executive directors, business owners. I hear these questions for them all the time. Um, but in my experience, the question of can I fire this employee tends to be the wrong question to ask, right? The better question instead is, can I defend the process that got us here in the first place? Right? And that's what we're going to really focus on today. And before we begin, just a quick disclaimer that I give before my webinars. This is informational, it's for educational purposes only, right? This is not legal advice. Every situation is unique, and attending this session today does not create an attorney-client relationship. So just want to make sure I get that out of the way so that we can begin. But as I mentioned, feel free to ask any questions that you have. All right. So the real risk. So I'm going to just start with a common scenario that we see often, especially if you manage employees, all right? So you have an employee, who's been driving everyone crazy for months, right? The manager's frustrated, coworkers are complaining, performance is suffering, right? Attendance is becoming a problem, right? Morale is probably declining as well, right? So eventually someone is going to ask, can we just fire them already, right? And maybe the answer is yes, right? Can we fire them already? Maybe. Right, but one thing we want to make sure is understood is that although we see over and over again that employers focus on employee conduct, I see that a lot of times the risk surrounding this decision tends to be overlooked, right? So the employee may be deserving of discipline, the employee may be deserving of termination, but that process it still exposes the organization to risk. So the process that you use in getting to that decision can still expose your organization to risk. All right. So it's not enough to say that, they were a bad employee. Okay. That's really when you get to that point, that's really when you need to slow down before making the decision, before actually pulling the trigger. That's your notion that you probably need to slow down and think through a couple of steps. Okay. So whenever an employee is considering termination or discipline, I like them to really pause, both literally, but also in the sense of this acronym that I have here on the screen. Okay, so pause stands for protected activity, alignments, underdocumented, statements made, events, and timing, right? So think of this as a risk assessment tool. It's not going to tell you whether you should terminate someone, but it will help you identify risks to make before you actually go ahead with the termination or discipline process. All right. And so I'm going to walk through each part with you just to give a better understanding of what these acronyms entail. Okay. So first we have protected activity for P. So this is where I see a lot of employers get into trouble. Okay, protected activity can include, reporting harassment, reporting discrimination, maybe they filed a complaint. Okay, maybe they're participating in an investigation that was initiated. Maybe they're requesting an accommodation. Maybe they requested medical leave, right? Maybe they raised wage concerns, worked some overtime and had some questions. Okay, maybe they're reporting safety issues that occurred while they were working. Okay, so keep in mind that protected activity does not make an employee untouchable. Okay, employees who engage in protected activity, they still can be disciplined. Okay, and they still can be terminated. Okay, there was a case that came out about, I want to say a year or two ago, Harris v. National Grid. Feel free to look that case up if you want a little bit more information. But that employer actually won because well, it was a retaliation claim, and that employer actually ended up winning because the employee was not able to prove that their termination stemmed from protected activity. Okay, the employer was able to show with enough documentation that the decision to terminate them was decided way before any protected activity occurred. And so in that particular instance, they actually did win win their case. Okay? So where protected activity is concerned, the issue really is that once the protected activity enters the picture, the employer just needs to be more careful, right? So it doesn't mean you can't terminate, it doesn't mean you can't discipline, it just means you just need to be careful about how you move about that. Okay. So here with protected activity, the question becomes, can we clearly demonstrate that this decision is unrelated to the protected activity, similar to the Harris v. National Grid case? Okay, so that's the question that you want to ask yourself. Next up, we have alignment. All right, so with this question here, when you look at alignment, you want to be able to ask yourself, are we treating this employee the same way that we've treated other employees? Okay, so consistency really does matter. We want to make sure that if you're treating one employee a certain type of way, you're treating others exactly the same way. Okay, so imagine maybe two employees have the same exact violation, right? Maybe attendance issues. One received a coaching, the other was terminated, right? What's the difference there? Okay, if you don't have a legitimate reason for the difference, you've already created a risk for your organization. All right. You want to make sure you're looking at the questions of, have we done this before? You want to ask yourself that. Okay, how did we handle this? Okay, is this a decision that is consistent with past practice that we've had in our organization? Okay, many discrimination and retaliation claims, they always begin with inconsistency in treatment. So you want to make sure that you're treating employees as the same across the board. All right, so that's for alignment. Next up, we have underdocumented. So I want to make sure. Okay, statements made, underdocumented. There we go. So for there, we want to really get into the documentation piece because a lot of employers, as you know, documentation is very important. Okay. So one of the most common things that I hear managers ask is, or managers say is, everybody knows that this employee is a problem. Everybody knows that, They've caused a lot of problems for our organization, or everybody knows they're annoying, whatever the case may be, right? But my response is always the same, right? Yes, I understand an employee may be a problem, but what does their file say? What does your documentation say about them? All right. Because if this case goes to court, right, the jury is going to be asking you that question. If an MCAD complaint comes through, the investigators are going to be asking you that. Or if it's an EEOC complaint, the investigators are going to be asking, where's the documentation? Okay. These are things that need to be proven. They care more about what you can prove versus what everyone thought about the employee. Okay, so good documentation should answer a couple of questions. It should answer what happened, right? When did it happen? Right? Who observed what occurred? What expectations were communicated to the employee? What coaching was given? What coaching occurred? What happened after the coaching? Did the behavior still continue? Right? So if your documentation doesn't tell that story, then that just opens the door for the employee to be able to tell a story of their own. And trust me, you do not want a situation where you're unable to tell the facts of what actually occurred. Okay? Next, we have statement made. So statement made, this section actually tends to be overlooked a lot. Managers, God bless them, but sometimes they can make statements that they don't think twice about, and that really just comes with more training needed for managers. I've had situations where managers have said comments along the lines of, she's always sick, right? When asking about medical issues. She's always playing the disability card, right? He's too emotional, or if it's someone older, oh yeah, he's old school because he's stuck in his ways, right? We need younger energy. These are actual comments that managers have said, right? And even though these comments weren't intended to be discriminatory, they really can create significant problems later on, right? So that's an area where we want to make sure that our managers are trained on communication and making sure that the statements they say don't pose risk for the organization later on. All right. Managers should really be focused on either behavior or performance, right? Anything related to personal characteristics, that should not be an area for them. That should really just be sticking to behavior and performance, and that's it. Okay. Next, we have events and timing. All right. So let's talk about timing. So timing should tell a story, right? So imagine a timeline like this where an employee complains about discrimination, and then 2 weeks later, they receive their first written warning. All right. And then a week after that, maybe they requested medical leave. Right. And then 2 weeks from there, they're terminated. Could that be lawful? Absolutely, it could be, right? But could it also raise questions? Absolutely. It will definitely raise questions. All right. And that's why timing does matter. So when I evaluate termination decisions, I always ask, all right, what story would an outsider tell based on this timeline? All right, what story would they see based on this timeline? Right? If the timeline looks suspicious, then chances are the employer needs a stronger documentation process and stronger justification. Okay, they have to be able to back up what the story that they're telling. If you can't back up your story with documentation, then that's a clear sign that you should pause and make sure that you're not pulling triggers without proper justification and proper documentation. Okay. All right, next slide. We have discipline versus termination decisions. All right, so before deciding on termination and discipline, these are questions that you should ask yourself. And feel free as we're going through these, feel free to screenshot whatever you need to screenshot. This recording will be available afterwards as well in case you want to go back and review it. But if you're not going to have that time, feel free to make any screenshots that you need to. So some questions that you should be asking, obviously, what even happened? Okay. Was a policy violated? Right? Because you also don't want a situation where someone may have done something, right? But there's no policy to back it up. Maybe your reasoning is that, oh, that's just how we do things here. They should have known. All right, well, if it's how you do things there, then it should be part of your policy. It should be a company policy. You shouldn't rely on the fact of, this is just, it's our custom, or this is, how we do business here, or this is how we conduct ourselves. If it's something that you want to be company culture, then your policy should reflect that. Okay. And that's Probably your cue to go and check your employee handbook and see what it says and make sure that it actually aligns with the company culture that you're looking to have in your organization. Okay. What documentation exists? Has the employee even been coached? You're seeing a behavior occur again and again and again, but you haven't spoken to them. The first time you're speaking to them, it's you telling them that that's their final warning. That should never happen. If you're seeing a behavior that's happening or reoccurring, make sure you're having conversations with these employees so that they actually know what they're doing and the behaviors can be corrected. Okay, we can't expect behaviors to be corrected if we're not addressing it as we're seeing it, right? Have other employees been similarly treated in this way? If you are giving someone a written warning because they were a no call, no show, but you're not giving written warnings to everyone, that's a problem. You want to make sure that you're treating everybody the same. Okay. You're looking to see, is there protected activity? Are there any leave or accommodation issues at play? You know, maybe there's a lesser discipline you can give. Maybe instead of a written warning, or instead of a termination, maybe this is just a coaching situation where they just needed a conversation. Okay. So the goal here is not to punish employees. The goal here is to make sure you're making thoughtful, defensible decisions. Okay. So make sure as you go through these questions, if these are questions that you have never asked yourself before making a termination or discipline decision, now these are questions you can ask moving forward before pulling that trigger. Right. So when does a PIP make sense? So for those who may not know, a PIP is a performance improvement plan. All right. So many employers ask, when is a good time to put someone on a performance improvement plan? And the answer, honestly, really, sometimes. There are situations where a performance improvement plan may not be appropriate, right? So if you are thinking about putting an employee on a performance improvement plan, you want to make sure that, first of all, what is the issue? Is it performance based or is it behavior? If it's behavior, a PIP is not going to be appropriate. We want to make sure that it is because of performance and we're looking for improved performance, which is why you're putting them on a measured plan. All right. What expectations can be measured? Okay, if you can't measure what you're expecting of them, then you need to go back and try to understand, okay, well, what's their job title? What's even in their job description? What tasks are you expecting them to improve on? If you can't clearly identify what tasks you're looking for improvement on, then chances are the employee can't identify it either. So you're expecting improvement based off of something that you're not even clear of yourself. That's not fair to the employee and that's not fair to you, right? So you want to make sure that you can give clear expectations and give clear measurables for the employee to be able to move forward and improve their performance. Okay. We also want to make sure that that improvement is even possible. We want to make sure that we're not setting them up for failure, but we're creating plans that can actually set them up for success and providing them with the tools that they need to actually succeed. All right. And we want to make sure that there actually is a structured path forward. Okay. After everything is said and done, what's the goal that we're trying to accomplish here? All right. So, like I said, a good PIP should, it should be clear, it should be measurable, it should be realistic, and it should be documented. I can't tell you how many times an employer or a manager put someone on a performance improvement plan, but had nothing to show for it. All they had were conversations back and forth with the employee. And when it went to court, they weren't able to show any documentation to prove that they were on an actual plan, right? So you want to make sure that you have your documentation taken care of. And also, another issue with performance improvement plans, before I move on, a PIP is not supposed to be used just to create paperwork so that you can terminate, right? Especially if you've already decided that this person is getting terminated, you've already bypassed the appropriate steps to take for performance improvement plan. All right, so the point is not to create paperwork to terminate. The point of a performance improvement plan is actually to have employees improve on their performance so that they can help push forward your organization. All right, so if you're not looking at a PIP in that way, I encourage you to start now and do so. All right, and if you have any questions about that, feel free to reach out, feel free to put it in the Q&A and we can talk a little bit more about that towards the end of the presentation. All right, final warnings. So a final warning can be an effective tool if it is used correctly. There are situations where a final warning is honestly extreme. It could have been a conversation, it could have been a written warning, it could have been, you just sitting down and showing them how to do things or just talking to them, right? I think a lot of times, communication seems to be lacking in that regard. But there are situations where a final warning as a beginning conversation is appropriate, right? If an employee did something pretty egregious, then you probably want to start at a final, right? And if you're unsure of when a final is appropriate or when maybe your coaching is appropriate, there's other trainings that we'll be having that will have come down the line as well. And so you can always tune into those. You can always reach out. But there are areas to determine when a final warning is appropriate. So when you're giving a final warning, first of all, it should be clear. It needs to explain why they're being given that warning in the first place. What is the problem? What even happened? Are they even aware of what they did? All right. What behavior has to change? Right? What is the timeline for improvement? You want to make sure that it is very clear what you're expecting of them in terms of improvement. All right. And you want to be clear as far as what consequences will occur if the behavior is not improved. Okay. So the purpose obviously is not punishment. The purpose is to be clear as far as if this continues, this is where you stand. And as a final warning, this is what we expect of you. If it is not improved, here are the next steps. We will be terminating, insert whatever other discipline you'd like to, or whatever other consequence you'd like to include there. Right. But the goal is to make sure that they understand where they stand within the company before they leave that meeting. And it should be a meeting. I've been in situations where an employee was given a final warning and they didn't even know that they had one because there was no formal meeting. It was just put in their file. And I understand that sometimes these conversations can be awkward, but these conversations are necessary. If you're going to issue a final warning, an employee should know that they have one and they should know why. Okay. And it's very, very important that that is not the first time they're hearing about it, especially if it's a matter that results in litigation. We want to make sure that if it does have to go to court, we're not trying to explain to a jury why that's the first time the employee was aware that they even had a final warning on their file in the first place. Okay. And if, according to your policy, there are certain conduct or certain behaviors that do warrant a final written warning, then just make sure that that's clear in your policies. Make sure that it is the way you're issuing discipline is in accordance to what your policies say. Okay. All right. So here's a termination checklist that you can save for later. And as I mentioned before, before you go into termination, just make sure to review these topics right here. So, as I mentioned, protected activity, leave requests, accommodation requests. What documentation do you already have lined up? Make sure your documentation is in order. All right. Make sure that you've been consistent across the board. Look at past discipline. How have you handled this in the past? And what transpired or what occurred from it? All right. Have there been any reports or have there been any complaints about maybe statements that a manager has made? What's the timing on this? Has anything occurred recently with this employee that should cause you to pause, right? What about your separation logistics? Have you arranged final pay? Okay. Are there any severance considerations that you want to put on the table? All right. So as you review this checklist, you also just want to make sure that one, this is not the first time, or during the termination meeting is not the first time you're looking at this checklist, but you want to make sure you review this checklist before you even pull the trigger on termination, because there have been instances where, risks were discovered while looking through this termination, and that caused the termination to be paused just simply from looking through this checklist and going through and making sure that everything was in order. But if you go through this checklist and you realize that there's nothing to worry about, no red flags, then yeah, go ahead and, do what you need to do to pull the trigger, but make sure you are first reviewing this before you open that. Because once that trigger is pulled, one, it makes things awkward, but two, you don't want to have to go back and negotiate or go back and be in the termination meeting debating on whether you're terminating an individual. It's not fair to them and it's not fair to the organization. Okay, so termination meeting best practices. So first and foremost, we know that these meetings can be very awkward. I've been in a number of them and they do get awkward and make you just want to crawl in a hole. However, there is a professional way to do them. There's a respectful way to do them, and it should be done quickly and concise. All right. So the decision should already be made. There's no reason why we're in a termination meeting and you're not even sure if you're terminating. That should never happen. If you are calling this meeting, it's because you are sure that you're terminating and you're moving forward. All right. And that should be decided before the meeting even begins. It shouldn't be done while the employee is waiting outside of the meeting. It should not be done while the employee is sitting in the meeting. All right. And it's not a time for debate. It's not a time to go back and forth and decide if you're going to terminate or not. All right. So this conversation should simply be focused on the decision that was made, next steps for the employee, giving them benefits information. If there's any property that needs to be returned, this is the moment to do so. And making sure that as you're discussing final pay, that that is communicated appropriately and making sure that their final pay is available to them that same day, especially in Massachusetts. You want to make sure that if you're terminating, that you are giving them their final pay, whatever PTO or anything that needs to be paid out, make sure that it is completely paid out to them. All right, so the goal here is really being professional and being respectful. It's not about persuasion or debating or anything along those lines. Okay. All right, so I do have some top termination related litigation risks. So these are top reasons in litigation um, that stemmed from termination. Right, so we have retaliation at number one. Okay, next, as a close second is disability, discrimination, and failure to accommodate. From there, we have medical leave, we have harassment, discrimination claims, and then finally wage and hours. So these are the top five reasons that people were terminated or people went to litigation and stated that these were the reasons why they believed they were terminated and why they have a reason to bring their employer, bring a complaint against their employer. Okay. So I do want to put this into practice. There are multiple Massachusetts court cases that touch upon each of these related reasons that we have here. But I do want to touch on the top reason, which is retaliation. I actually found a case that touches on both retaliation and failure to accommodate. And I want us to put this into practice, and I want to be able to, for you, before you leave here, to see how we practically walk through the pause framework so that before you go through termination, before you pull that trigger, you're also able to go through that framework on your own and come to a decision that won't open your organization up to risk. Okay. So let's see. So the case that I'm using today, it's actually an MCAD case, and it was decided not too long ago. I think it's just maybe about a year or two old, not too old. So this is Stephanie Joseph v. Massachusetts Department of Children and Families. And this particular decision, there was another one, but just for the interest of time, I'm only going to focus on this one case today. And I can share more cases. If anyone is interested in looking at any other cases of interest, feel free to let me know and I can send those over to you for you to review. But I think just for the sake of this particular webinar, I'll just go through this one, just so we have enough time for questions at the end. And then in future webinars, if we do have time, I can make sure to deep dive into more than one case so that we can get more practical experience, okay? So to give you a little bit of information about this particular case, Stephanie Joseph was a social worker for DCF. She had a surgery based on a serious medical condition that she had, and so she needed to take time off work. She attempted to return to work, but she needed restrictions, and those restrictions were recommended by her physician. And those restrictions included reduced hours, reduced caseload, and other temporary accommodations that she requested for. Initially, DCF did deny her request, and they argued that they shouldn't have to approve it since she wasn't able to perform the essential functions of her job. Later, she continued requesting help from the ADA coordinator at the facility. And once she started reaching out for help from the coordinator, management's tone started shifting a little bit, unfortunately. So there was an instance where there were some internal emails going back and forth where supervisors were complaining that, this employee went over their heads to go to the coordinator and that she's taking advantage of the ADA accommodation process and she's fine and all of those, right? Shortly after those conversations were had via email, her accommodation request was unfortunately denied. And then anytime she would go into meetings, they would criticize her. They called her a liability. And then eventually, a manager sat down with her and told her that she had three choices. They said either you return to work against your doctor's restrictions, either you go back on unpaid leave, or you resign. So, based on all the pressure she was receiving, she immediately resigned the next day. And then, shortly after, DCF received an MCAD complaint, which is how, if your organization ever received a complaint, the first thing you're going to have is that before it goes to litigation, the first thing you will receive is a complaint from the MCAD. Anywho, MCAD did find that DCF failed to accommodate her disability. They found that they did retaliate against her after she engaged in protected activity, and they constructively discharged her. All right, so in this scenario, they didn't terminate her per se, but they did constructively discharge, which means that they forced her hand to resign, which is similar to a type of termination. Okay. And it's constructive discharge is definitely something that you don't want to find yourself in. All right. So let's apply the pause framework here. All right. And so I already kind of have it for you here. I know the font is kind of small, so hopefully you can zoom in and see that. Okay. So for protected activity. All right. So she did request accommodations and she did seek help from an ADA coordinator. So right then and there, we see protected activity. All right, so before they did anything to her, they should have known right then and there, this is protected activity. We want to make sure that we're not doing anything that could be deemed retaliation. We want to make sure that we don't do anything that could be deemed discriminatory. All right, obviously, they didn't have the pause framework, but hopefully now you do, so you won't. This is at least a learning opportunity for us. Okay. So next we look at alignment. All right. So other employees actually did receive accommodations similar to hers, right? So it's unclear why they refused to accommodate her, but they accommodated many others for the same type of things, for reduced workload, for reduced hours. It's been done before in the past, yet they denied her. All right. Documentation. So for underdocumented, DCF claimed that, that there was an undue hardship in accommodating her request, but they couldn't show that they did a meaningful analysis to support that conclusion. All right. They didn't have any documentation to show that they spoke to this employee. They didn't have any documentation to show that there was an interactive process. They didn't have any documentation to show that they thought through everything and came to the conclusion that there was an undue hardship. All they had was their word, and in court, your word is not your bond. You need documentation. Okay. Next, for statements made, right? The emails that they had back and forth, that was pretty much the smoking gun. Okay. So in the email, we see that the managers were complaining that, she's taking advantage of the accommodation process and she's a liability and, she went over our heads to go to the coordinator. All of those comments that were made were used as evidence in this matter. And it was very powerful evidence. Make sure you're not saying things like that in email, guys. Just make sure you're not. All right. And finally, we have events and timing. Okay, so this timeline did tell a story, right? We could see the negative treatment, and it really started almost immediately after she had protected activity. So it was about a month time frame. So we see from the moment that she had her protected activity and sought accommodations. Between that and the moment that she resigned was about a month's difference. So each week was something else. Okay. In week one, she sought accommodations and sought help from a coordinator. In week two, emails going back and forth about how she's taking advantage of the process. About week three, she was denied accommodations. And about week four, she was given the ultimatum to either resign, go on unpaid leave again, or come back to work without restrictions against her doctor's advice, right? So, although DCF tried to argue that it was undue hardship to have her, have a reduced caseload and not have her at work, this case really was about process. All right. So DCF didn't lose because they denied her accommodation. That's not even the reason why they lost. They lost because they failed to engage in the interactive process. They lost because they didn't even investigate what accommodations would have created a hardship for them, right? They lost because managers were frustrated and put things in writing that should have not been in writing, and they did not help her when they should have, right? They lost because those internal emails that they had were pretty hostile toward the accommodation request. Okay, clear as day, right? They lost because the timing of management's actions versus her resignation, those things created an appearance of retaliation. Okay. So those are the reasons why. So it's not because they wanted to deny the accommodation. It was everything else related to their process. All right. So the lesson here, the lesson that we see is that it wasn't the accommodation that created the liability. It was the employer's response to the accommodation that created the liability. All right. So the lesson here, it's not that you have to grant every accommodation request that comes through the door. Okay. The lesson I want you to take here is that when an employee engages in protected activity, your process matters just as much as your decision does. All right. So if your documentation, if your statements, if your consistency and your timing don't support the decision, then you may be creating risk for your organization, even if you believe you're doing the right thing. You might very well be doing the right thing, but you just want to make sure that your processes can also back up the fact that you're doing the right thing. Okay. All right. So some key takeaways. Again, as we discussed before you discipline, before you terminate, make sure to pause. Make sure that you are looking at if there's any protected activity, alignments, whether it's underdocumented, whether there were any statements made, whether there's any events or timing that should cause you to take a step back before you pull that trigger. Okay? Because the strongest employment decisions are not what's legally defensible. Okay? It's what's well documented, what's consistent, what's thoughtful, but most importantly, what's fair. Okay? So that's the and so, if there are any questions, feel free to ask. I hope at least that in what we've gone through so far, that you're able to leave with practical framework that you can use almost immediately in your organizations and apply when there's any difficult employee relations issues that arise. And also just remembering to leave here, understanding that the question is not simply, can I fire this employee? But the question you should be asking yourself moving forward, especially after this training, is can I defend the process that led to this decision? Okay. So, any questions? All right. Just go to the Q&A box. One moment. All right. All right. Oh, thank you, Patty. I appreciate that so much. And yeah, and based on Patty, so Patty had just mentioned just a comment about the seminar, about the examples, and these are true examples. You're exactly right. And I'm sure, especially with the other HR professionals that are in this seminar, I'm sure you've dealt with a lot of these quite a bit. And so one thing I want to make sure that you all leave here with is, if there are any other examples that you have or any particular situations that you've been through with this, feel free to leave that not only in the chat, but if there's, you can also reach out via email. You can put it in the Q&A, but I'm going to make sure at least moving forward in other webinars that I do, if there's any particular instances that you've seen firsthand, I'd be more than happy to go through those. I'd be more than happy to pull, if there's particular cases that you're interested in, I'd be more than happy to look at that as well. Okay. All right. All right, so the next question that we have here, it says, what if a warning results to some kind of assault happening? Oh, that's actually a pretty good question. All right, well, first and foremost, if you are sitting with an employee and you're issuing them a warning and it results to an assault, I mean, first, I would hope that that would definitely lead to a termination. I mean, that's actually happened in one of my organizations where things did get physical. That employee was escorted off the premises by security, and that did lead to their termination. Okay, there's should be a zero tolerance for any type of assault, right? That shouldn't be tolerated in any fashion, any shape, or any form. Right? Violence in any form should not be tolerated. Okay, so when you're sitting with an employee, you should always make sure, one, that you know why you're meeting with them. So if it's a warning, it sounds like that's something that at least they've been coached about before. And if it's not something they've been coached about before, as you're sitting with them, you should make sure that you have clear steps on one, why you're meeting, two, steps on how to move forward, right? And expectations that you have of that employee moving forward. Okay. Why it may turn physical, it probably depends on the reason for the meeting. But the goal is to make sure that when we're meeting with these employees, that they understand that we want them to improve. We're not, it's not us against them, it's not employer against employee, but the real goal of these meetings should be to improve the behavior. And so if meetings are bringing out the worst in them, then I think if anything, that's your cue to let them go. All right, and that's done. Okay. And feel free to, continue. Okay, so someone had another question. All right, and we do have a little bit more time. So as you're putting your questions in, I'll get to as many as I can. Performance improvement. Okay, so with a performance improvement plan, and if you can just clarify, so what I'm seeing here, mostly just what is a performance improvement plan? So I'll answer what a performance improvement plan is and go a little bit into what that process looks like. Okay, so a performance improvement plan, if you're noticing that an employee is struggling, maybe you've already coached them, you've spoken to them a couple of times, but you're noticing that they're still not improving or they're still struggling, and it's not only affecting their workload, but it's also affecting operations. I would say that is definitely a time where a plan should be put in place for them to improve. The goal is for them to improve, right? So you want to make sure that you're able to identify exactly what you need them to improve on. Um, so let me get industry specific. Let's say you're a nurse, right? Let's say the employee is a nurse and you're looking for them to improve maybe their bedside performance, right? Maybe the way they talk to patients or maybe how they treat patients. Maybe it's you want them to make sure that they're washing their hands before they deal with patients, right? And maybe they're not washing their hands, or maybe they're not speaking to patients correctly. Maybe they're not administering the medications the way you need them administered. Maybe they're not doing their checks, right? Maybe part of their task is that they're helping with checks and going, from room to room checking on their patients. And they're not doing any of these things, right? Maybe they don't know how. Maybe the issue that you have with them is that they're not doing their proper documentation. They're meeting with patients, but they're not documenting appropriately, right? So those are things you want to make sure if you're doing a performance improvement plan, that all of that is listed clearly in the plan, but you're also including how they can improve from that. What is the actual expectation, right? You're expecting that moving forward, anytime they touch a patient, they're documenting it. Anytime they're administering medication, they're documenting it, right? You want to make sure that if it's a matter of how they speak to patients, that you're clearly stating what is the behavior that they are exhibiting that you need corrected, and you're giving them steps on how to do that, right? If it's a matter of bedside manner, right? There's trainings for that. Maybe it's you issue them a training and have them sit down and rewatch their bedside training. Okay, so you want to make sure that you're giving them the tools that they need to succeed and a time frame. So how soon are they supposed to improve on this? Most of the time it's immediately. Obviously, you want immediate improvement, right? But from there, is there a time frame? Are you giving them 2 weeks to fix this? And in that 2 weeks, are you precepting them? Are you shadowing them to make sure that if they have questions, you're available for them to ask questions? Right. So those are some things you want to keep in mind with the performance improvement plan. And if at the end of the time allotted, at the end of the 2 weeks or 4 weeks that you've given them, if you notice that the improvement still isn't there, you are at a position to either extend the performance improvement plan. Maybe you extended another week or two. Maybe you saw some improvement, but there are still some areas that you need them to improve. So in that situation, you extend it. And that'll also show them that you really are trying to work with them, right? Maybe you've extended it twice already. I've been in situations where we extended it 3 times and there was still no improvement. And at the end of it, most times you find employees may tend to resign because they don't want to get terminated or they sense that they're about to be terminated, so they resign. We've had situations where we did have to sit with the employee and have that termination conversation. Okay, but that's what that would look like. All right. So next question, how can you differentiate between an employee struggling versus an employee doing the minimum? All right, that's a great question. So when you're working with an employee and they're struggling, you can notice when are they working with you, right? You've given them all the tools that they need to succeed, right? Are they working with you? Are they communicating what the struggles are, right? When you sit with them in these meetings, well, actually, let me backtrack. In these performance improvement meetings, right, you should be meeting with them consistently, whether it's you're meeting with them at the end of the day, whether you've decided that you're going to check in weekly with them. But when you're doing these check-ins with this employee, what are the conversations like? All right, are they showing you exactly what they're struggling with? And when you give them the tools to succeed, do you see that they're actually using the tools? All right. Going back to maybe the medical example, let's say they're struggling with scanning medications and they need to get their numbers up, right? Maybe they're not scanning it as much as they need to. Is it that they just don't want to use the scanner? Or is it that they don't know how to use the scanner? And now you've shown them how to use it. And when you check in next week, you see their numbers improve. Okay. So those are things you want to keep in touch. If it's a situation where the conduct, once you've given them the tools, it should improve and it's not improving, and you're asking them and showing them what your expectations are, but they're not meeting expectations. I think at that point, it's really up to the employee to either continue to ask for the help that they need and use the tools that you're giving them. And if they're not using the tools and if they're not asking for help and you've provided everything that they need and you get to the end of the performance improvement plan, then I think that will show you everything you need to know. But usually you can tell, at least by the employee's behavior, whether it's a matter of them just not wanting to do the work or them just struggling, right? And we've been in situations where it was probably that the job just was not the right fit for the employee, which is fine. There are times where a job just might not be the right fit, and you are in a position to help them find a role that is going to be a right fit for them. I've had performance improvement plan meetings end where the employee actually wanted to find a different role, and we connected them with talent acquisitions, and they were able to find something more fitting for them. Right? There are situations where employees are put in other positions because they want to rise up in the company. They get to a position and it's not what they thought it was going to be. It's everything they thought it wasn't going to be. Or they end up hating it and they actually want to go back to their old role or try something else. But I think if you're both willing to have that open and honest conversation, then that's even one way you can retain talent in your organization as opposed to losing people who could have been a really good asset to your organization. Okay. So I don't see any more questions in the chat. If there are any more questions, feel free to ask. If not, feel free to email me. Most of you do have my email, but if you don't have my email, it is xrobinson@mahaniumlaw.com. And feel free to add me on LinkedIn. If we're not already on LinkedIn, you can feel free to add me there. It's Xena Robinson. My name's on the screen. Um, And if there are no other questions, I want to thank you for joining. The next webinar will be next month. It's looking like that conversation will be on documentation because some emails that I received were surrounding wanting more information on proper ways to document. So it's right now it's not decided, but unless I get any other topics that people are interested in, that would be the next thing that we're going to be discussing in July. So I want to thank you so much for joining, and I hope you have a great afternoon. All right, take care.